Mr. Justice K.V. Vishwanathan, sitting judge of the Supreme Court of India. Sir, it's our absolute pleasure and honor to have you with us today at the closing ceremony of the 5th International Summer School on Mediation, which started on the 26th of July, 12 days ago. A very warm welcome to our guests of honor, Mr. Gregory Vijendran, Senior Counsel and Board Member of SIMC, Singapore International Mediation Center, and Mr. Hassan Khan, Vice President, Commonwealth Lawyers Association, CLA. A special and heartfelt welcome to all the students, peacemakers, mediators, and enthusiasts of mediation who have joined us today from across the world. Nivaran, a society of mediators of the Supreme Court of India, has the privilege of collaborating for the summer school with the SIMC and the CLA. I am Shireen Khajuria, a Supreme Court accredited mediator, an arbitrator with ICA, and a senior counsel of the Supreme Court. I was fortunate to have Mr. A.J. Jawad, a speaker at the summer school and present here today as my first mediation trainer in 2019. Thank you ever so much, Jawad. I have also completed training by the ADR ODR International London and was on the panel of mediators of SIMI. It's my privilege to be a trustee of Nivaran and an honor to conduct this closing ceremony of the Summer School 2024. The summer school has been an incredible experience for me, and I hope it was the same for all of you. It's my pleasure to now introduce Mr. Jitinder Sharma, who will give the welcome address. Sharma ji is a senior advocate, Supreme Court of India, and an accredited mediator with the Mediation Center annexed to the Supreme Court of India. He underwent mediation training at the Singapore International Arbitration Center and the Harvard Law School in 2007-8. He's a passionate proponent of mediation, which is evident from the fact that he's the founder president of Nivaran, which was set up with the object of promoting mediation. Nivaran, as many of you know, means to resolve. May I now request Jitinderji to please give his welcome address. Over to you, sir.
Thank you, Shireen. Thank you so much. Good evening, good morning, and namaste to all our viewers. On behalf of Nivaran, a Supreme Court Mediators Initiative, and on behalf of our 5th Summer School partners, Commonwealth Lawyers Association and Singapore International Mediation Center, I welcome Honorable Justice K.V. Vishwanathan, Judge, Supreme Court of India. He is a patient listener who has empathetic appreciation of factual situation and deep understanding of human and cultural values. As a judge, we see him in courts every other day. Such of these qualities actually are the essential qualifications of a good mediator. Our guest of honor, Hassan Irfan Khan, is the Vice President of Austro-Asian region representing Commonwealth Lawyers Association. He is a senior advocate practicing in Pakistan. He has a wide range of experience in intellectual property, life sciences, corporate, commercial, and various high-profile cases in Pakistan and elsewhere. I welcome Mr. Khan. Our next guest of honor is Gregory Vijendran, Senior Counsel. He has been a longest-serving bar leader in Singapore. He finished a 5-year presidential term in 2021. He continuously served an important leadership role for the legal profession, mostly pro bono. He has a great interest in ethics and following legal professional ethical values. I welcome Gregory. For the last 10 days, all participants joining from various parts of the globe have patiently and regularly joined the summer school, where the sessions are normally scheduled for about 60 minutes plus, which includes about 15 to 20 minutes question and answers. But the enthusiasm in asking questions from the participants had often exceeded the time limit. Thank you, participants. It is for you only this summer school is. I quote, knowledge is power, information is liberating. Education is the premise of progress in every society, in every family. Kofi Annan, unquote. Acquiring literacy is an empowering process, enabling to enjoy access to knowledge and information, which broadens the horizon by increasing opportunity and create alternatives. Knowledge requires regular brushing up and update, which could not have been possible without our guest speakers faculty, who accepted Nivaran's request. The list of speakers comprised from Australia, Singapore, South Africa, Kenya, England, Canada, Caribbean country, and of course, from India. Despite having a different time zones in the session, which included 2 weekends, the speaker joined early in the morning or late in the evening. Thank you so much, guest speakers faculty, without whose cooperation this school would not have been possible. As you are aware, the Nivaran has been since last more than 4 years, continuously making efforts to spread the message and awareness about mediation through web lectures, interactive sessions, and summer school. Nivaran has been in partnership with some universities where our members are frequently and regularly visiting and giving lectures to students on mediation and allied topics. Thanks once again to all the participants and guest speakers, faculty, and hope to see more and newer participants next year. Thank you so much. Shireen.
Thank you so much, Jitinderji. We are proud to be a part of an organization like Nivaran that values learning and growth in mediation. And we are grateful for the opportunity to contribute to that mission. I would also like to sincerely thank each of the 10 speakers of the summer school who were from across the world. On the first date of summer school, Honorable Miss Rennie Baptist had introduced mediation and given us an exciting insight into the Caribbean experience of mediation with her innumerable interesting examples. On day 2, Mr. A.J. Jawad, one of the leading mediators and trainers in India, kept us engrossed with his presentation on the historical perspective of dispute resolution, the development of legal systems, and awareness of different cultures. A dry topic made most interesting by you. Thank you, sir. The speaker on the third day of the summer school was the vibrant Ms. Archana Medkar, an accredited family mediator and arbitrator in Australia, besides being a barrister and a part of the organization Mediators Without Borders. She gave an in-depth talk on better utilization of online mediation, its advantages and disadvantages, including how important the tone and body language can be even on online mediation, and in fact, maybe especially in case of online mediation. On the fourth day, Honorable Lady Justice Joyce Aluj, a judge of the High Court of Kenya, discussed the extremely important issue of ethics in mediation, the concept of confidentiality, neutrality, and self-determination, which form the pillar of mediation. On the next day, we had the pleasure of listening to the delightful and soothing talk of Ms. Sarah Blake on the overview of conflict, the styles of conflict, conflict management, resolution, and transformation. She is surely a natural conflict resolutionist. Mr. Andrew Miller Casey covered negotiation and the negotiation skills needed for a mediator on the 6th day of the summer school. He emphasized on the fact that focus of a mediator should be on the mediation process and not on the final settlement. On day 7, we had a very interesting session on interpersonal communication skills needed for a mediator by Professor Andrew Goodman. Mr. Duncan Turner on the 8th day spoke about mediation advocacy. He in fact distinguished between advocacy for mediation, which is promoting mediation like Nivaran does, and advocacy in mediation, which is by a party representative. On the ninth day, Ms. Chitra Narayan, lawyer, senior mediator, and author, besides being a mediation lecturer, focused on the Singapore Convention on International Commercial Mediation, which has been ratified by 14 countries. She also clarified the stand of the Indian government on waiting to ratify it. The 10th day witnessed a completely different style of lecture, an experiential interactive session by Mr. K.S. Sarma, an erudite coach, negotiator, and mediator, who said that the Sustainable Development Goals, SDG, and mediation, in fact, form the bedrock of the other 16 SDG goals set by the United Nations for a fair, just, and equitable society. The practical strategies and real-life examples by the speakers have given me and our august audience comprising of students, experts in the field, advocates and mediators, and people from all walks of life who were present, valuable tools to manage conflicts more effectively in mediation. And we express our deep appreciation to each of you. Thank you. We're also extremely grateful to each of the hosts of the summer school, Ms. Nandini Gore, Ms. Prabha Swami, Ms. Rima Bhandari, Mr. Anil Srivastav, Ms. Praveena Gautam, Mr. Devraj, Mr. Nikhil Jain, Ms. Sangeeta Mehrotra, Ms. Mritula, Ms. Manjula Gupta, and Mr. S.S. Ray, who seamlessly conducted the proceedings with the guest speakers and have been an integral part of the summer school. The summer school would not have been what it was without each of you. Your hard work and dedication are much appreciated. Thank you. May I now introduce our guest of honor, Mr. Hassan Irfan Khan, the Vice President of the region for the Commonwealth Lawyers Association. He's a senior advocate.
Go on,
Mr. Khan, I'll just introduce you and then the floor over to you. He's a senior advocate, as was mentioned by Jitinder Ji, admitted to the practice before all the high courts and the Supreme Court of Pakistan. His practice began focusing on intellectual property laws, and he's a recognized leader in this area of law. Though over a period of time, he has created a niche as a senior litigator across various other areas of law too. He has conducted various high-profile cases before the courts in Pakistan, including a recent presidential reference to the Supreme Court concerning Senate elections, constitutional challenge to competition law, and constitutional challenge to Drugs Regulatory Authority Act. He has led various pro bono projects and is a philanthropist. He is the managing trustee of the Irfan Family Foundation, which focuses on health, education, poverty, protection, and conservation of the environment. Mr. Khan has keenly participated in matters of CLA, that's the Commonwealth Lawyers Association, and led a pro bono project on behalf of the CLA relating to child sexual exploitation and abuse in collaboration with the organization It's a Penalty. He aims to strive to expand CLA's horizons and awareness in Pakistan as also other developing nations through his large network of friends and business associates. He aims to work to arrange seminars, discussions, and conferences for CLA members on the national scale, regional scale, or international scale, and would like to work on encouraging the members to write articles and research papers. Over to you, Mr. Khan. Thank you.
Thank you very much, Shireen. Good afternoon, good evening to all the participants. It's my pleasure and honor to be here. And particularly, I would like to welcome Honorable Justice Vishwanathan on behalf of CLA. And my special thank to Gregory and of course, Santan to invite me to speak as a guest of honor on behalf of CLA. It's such a pleasure to be here and to see almost 143 participants. It's a very encouraging aspect and a very appreciable aspect. I would begin by introducing CLA, which needs although no introduction, but as a vice president, I think it is my duty to speak a little bit about CLA. So CLA is a dynamic organization of volunteer lawyers who have got together to promote the rule of law, human rights, businesses throughout the Commonwealth, and arresting climate change, particularly within the Commonwealth and throughout the world, and in particular talking about Commonwealth, about the island states, because the climate change is a serious challenge that we all face throughout the world, and it is not within a specific country or a region. It is affecting everybody. So Commonwealth Lawyers Association is very actively working amongst other areas on the climate change aspect. And we arranged a Borneo conference in February this year in Kota Kinabalu, which was a thumping success. We are also going to have an annual conference, our conference in Malta, and you are all encouraged to attend and be part of that conference and also be part of the membership. We have several committees within the CLA, and the notable committee that I would like to emphasize in this forum is the Young Lawyers Committee also, and we have extensive young lawyers programs. So all of the young lawyers are encouraged to participate. Also about the rule of law, human rights, businesses. So it's a dynamic organization, and the support that we get from all the lawyers, all the volunteers is appreciable. Now coming to this particular Nivaran mediation program, it is so heartening to see Justice Vishwanathan come and speak as a chief guest, which also suggests that the courts are throughout the world, of course, in Pakistan also, are encouraging. And I must also mention and appreciate the online telecast of the Supreme Court proceedings, which I very regularly actually watch during the end of the day. And it is such a good learning experience for even the senior lawyers also. So it is really excellent, as we have just been told, that the luminaries and the expert people from all over the world have come and spoken about the mediation aspect. The activities of Nivaran are appreciable, which, as I have learned, not only relates to the summer schools, but also hosting webinars, seminars, and guest lectures, which all not only actually train the young lawyers, but it enables the senior lawyers like myself and so many present here to remain updated and continue the development. And I think now, particularly in countries which have legal backlogs of decision making, this mediation is an excellent way, and it is encouraging people to resolve their issues rather than go through the tedious and the lengthy legal proceedings. So all this training aspect is very encouraging for everybody, and for the lawyers also, for the litigants also. And I think in the years to come, we will see all a positive result. So once again, on my own behalf, on behalf of CLA, I would like to thank you all for having me here as a guest of honor. And I wish all the best and all the success. And I do also wish that during the next seminars or the programs, we would have more participants from Pakistan also. So we need to extend that thing as well throughout the Commonwealth and throughout our countries. Thank you very much indeed.
Thank you so much. Thank you so much, Mr. Khan. And thank you for sharing about the aim and the work of the CLA, and that there is a young lawyers committee. I'm sure the students over here would like to know more about it, and I'm sure they could check out about it. I remember on the opening day, one of our speakers had said that mediation denotes the cultural evolution of a society. The maturity of a society, they said, can be measured by how many members of the society take to mediation to resolve their dispute. And I could not agree more. As we have seen over the last 10 days, mediation is a self-determinative process where the parties show their maturity by resolving their disputes voluntarily by themselves rather than approach the courts and judges to settle their personal disputes. even though one of the reasons advocated for mediation is that it cuts through the long drawn and unpredictable process of litigation and also reduces the burden of the courts. Those, I believe, are the fringe benefits of mediation. The primary reason to advocate and adopt mediation is that it is not just an ADR, an alternate dispute resolution mechanism, but the best ADR. And I'm sure that's what Nivaran Summer School has shown us. May I now introduce you to our eminent guest of honor, Mr. Gregory Vijayendran. He's a senior counsel and a former president of the Singapore Law Society, as Mr. J.M. Sharma mentioned. He's also the longest serving bar leader in Singapore, finishing a 5-year presidency term in 2021. Though he continues to serve in influential leadership roles for the legal profession, including in pro bono and ethics. Notably, as the president of the Law Society, Gregory successfully managed the COVID scenario. He and his team, comprising of Law Society's COVID-19 task force and the Secretariat, were successful in getting the legal services recognized as essential services during those trying times. It's due to his efforts that many legal professionals were able to survive the pandemic. He's a well-respected board member of the Singapore International Mediation Center, a premier institute with whom Nivaran has collaborated for the present summer school. Mr. Vijayendran is also a CLA Council member for Singapore, serving on the mediation and arbitration committees. He has a wealth of experience and expertise in various spheres of civil criminal litigation, besides in arbitration and mediation dispute resolution. He has been deeply engaged in community-based legal clinics. Mr. Vijayendran, can I now request you to please give your address?
Thank you very much, Shireen, and good afternoon, good evening to all present online. And I think our numbers right now would be, according to my count here, some 140 plus?
161.
It's 161 now, yes.
161, so it's ascending, as the evening unfolds. I'd like to welcome also our chief guest, Honorable Mr. Justice K.V. Vishwanathan, and also very pleased to have my colleague on the Commonwealth Lawyers Association, Vice President Hassan Irfan Khan, whom you have heard from and whom I echo in terms of the CLA opportunities that he shared about. We had the privilege of being together in Kota Kinabalu, and I've also spoken to the young Commonwealth Lawyers Association, and we're both equally passionate about mediation. It's a great joy to speak to such a learned crowd, and you've had much learnings, you've had tutelage in very nuanced facets of mediation. Just listening to Shireen's recount, and it's a great privilege and honor for me to be here on the invitation of President Santan, a dear old friend. I'm just going to share some very brief thoughts with us in the spirit of learning about whether catharsis, you heard me right, CATHARSIS, is a hidden advantage in mediation. I was trying to do some quick research, and I'm not sure I have found the answer to my question. The question was whether Indians are more extroverted or introverted as a nation, as a whole, as a populace. One study puts it at 50-50. Another one suggests that 1 in 3 Indians are introverted. Another one says that, generally for South Asians, they are more extroverted. Now, whether you're introverted personally or extroverted, I want to say that an often ignored, obscure, but hidden advantage of mediation is catharsis. What is catharsis? It is about venting one's anger, one's emotion that is beneficial towards improving your psychological state. The word catharsis comes from the Greek word K-A-T-H-A-R-S-I-S. So it's like catharsis except K instead of C, which translates into cleansing or purging. And catharsis, I want to suggest from experience and also from observation, is especially relevant in the disputes that we are called to mediate, where relationships between parties have been strained. And in virtually all relationships that we see coming up in the context of mediation, there is certainly some underlying relational issue that will be present. It's a question of degree, how dominant it is. In an article published by John Tyrrell for the Australian construction newsletter, Practical Commercial Mediation Issues, he explains that mediators as humans tend to control the matter or conduct, and emotional outbursts are usually suppressed and not encouraged. We're all uncomfortable with them. We find it messy. We find it difficult to deal with, and perhaps we're not trained. But this venting process is actually very important, and at times even essential to the capacity of the parties to move towards resolution. And the suggestion by Tyrrell is that sometimes the greatest progress in the dispute may actually be made during the periods when the mediation seems the most out of control. That may sound very paradoxical, but there is good rationale, because if people are allowed to clear the air by letting out their frustration, their anger, their annoyance, and perhaps even hatred, that could help parties to move on. Now, there is a balance, and Tyrrell makes it clear that while venting may be helpful, we need to be mindful of, number one, the extent, number two, the duration, and number three, the capacity of the other party to accept such a behavior. And you can, at a moment's reflection, realize why, because if you don't manage that well, then the emotional outburst may well fall into the realm of toxic behavior, which could be detrimental to the mood and the momentum in reaching an amicable mediated agreement. But mediation offers us this opportunity to have parties vent their grievances with the goal of hopefully gaining overall relief from strong and repressed emotions. In another article entitled Introduction to ADR, a comparison between arbitration and mediation, written by Rice Clift, the author says, there is no doubt mediation is an extremely effective way to settle commercial disputes. And one of the reasons for that is that mediation can actually be seen as a substitute day in court. In mediation, parties have the opportunity and space to do it freely. It's cathartic. It releases the pent-up tensions that could otherwise preclude negotiation. So we need wisdom. Some people would reserve this more for the caucus sessions or the breakout sessions, as they are called, or the sessions between one party and their counsel together with the mediators. And that could be a sensible approach, where people have that cathartic moment without alienating the other side. And some mediators have highlighted that some of the disputes were almost always business-related, and private caucuses guide parties to transcend emotions to reach an amicable business resolution. So in conclusion, mediators are skilled not just in identifying problems, but in carefully separating people from problems to guide them to a commercial business arrangement that is a fair business decision, rather than a decision heavily influenced by emotions. But one of the tricks of the trade, or perhaps even armory, that you could adopt as a mediator is to consider how you could use the private caucus sessions for people to vent their emotions in that setting, so that it might lead to a moment in which it could transcend and even gain a momentum to a mediated settlement. So I want to leave these fairly controversial thoughts about this hidden advantage for you to reflect on as good learners of mediation. Thank you very much for this opportunity to invite me to share some thoughts.
Gregory, thank you so much. for your insight and thoughts, which are really, for your thought-provoking idea, in fact, on catharsis and venting and how important it is in mediation. I think that was an area which possibly we hadn't really reflected on too much during the summer school. And your thoughts on that have been very interesting. I'm sure we'll all have a lot to think about. In fact, recently we were discussing on the ambassador group as to how the Japanese art of kintsugi is similar to mediation. Kintsugi is a Japanese art of repairing a broken object by using gold paint or powder, which makes the object, in fact, a better version of itself. So, mediation, in fact, gives us an opportunity to be a better version of ourselves. I thought that was an interesting thought to take home. May I now please introduce our chief guest, Honorable Mr. Justice K.V. Vishwanathan, Judge of the Honorable Supreme Court of India. It's my absolute delight, sir, to introduce you. Honorable Justice Vishwanathan is not only an eminent but also a well-loved and respected former member of our Supreme Court bar, who was elevated to the Supreme Court of India as a judge on 19th of May last year. Honorable Mr. Justice Vishwanathan has the rare distinction of being amongst the few lawyers to be elevated straight from the bar to the bench of the Supreme Court of India. As stated in the collegium order appointing him a judge, he was elevated because of his sound understanding of law, his profound knowledge, his integrity, and his wide experience. Many of us who have worked with him prior to his elevation and have had the privilege of knowing him have seen that Justice Vishwanathan has this absolutely admirable ability to be totally in the present moment. Whether he's speaking with us at a casual gathering, or being briefed, or listening to arguments in court, or I think even playing with his cat. This is what we in mediation call active listening. Also, though he has a judge, he has this ability to be completely non-judgmental about people. Again, a perfect quality for a mediator. Justice Vishwanathan has had a meteoric rise. He completed his integrated 5-year law course from the Coimbatore College of Law and joined the chambers of the renowned criminal lawyer, Mr. K.A. Ramachandran, for a few years before he moved to the Supreme Court of India in 1988. He joined the chambers of Mr. C.S. Vaidyanathan, senior advocate, and thereafter the eminent senior counsel, Mr. K.K. Venugopal, former Attorney General of India. Justice Vishwanathan started his own practice in the year 1995 and was designated a senior advocate by a full bench of the Supreme Court of India at the young age of 43 years. Normally in India, the designation happens only after the age of 45. He was appointed as an additional Solicitor General in 2013. He has been an eminent member of the editorial board of well-known Indian law journals, including the Supreme Court cases. He was also appointed as a member of the NALSA, a premier body set up to provide free legal aid to the needy and the overarching body for mediation in India. Justice Vishwanathan, while he was an advocate, has argued innumerable landmark cases in the Supreme Court of India, including as an amicus curiae, a friend of the court, for many years prior to his elevation. These include the landmark constitutional matters like right to privacy in the Aadhaar matter, WhatsApp, Facebook privacy matter, validity of extension of tenure of the ED director as well as the CBI director. He has supported and taken up pro bono matters for teachers and the personnel of the armed forces while practicing as an advocate because his heart lies with them. He has authored as many as 21 judgments in his short tenure of 15 months as a judge of the Supreme Court of India. They encompass various topics from civil to criminal law, to arbitration, to special commercial laws, consumer insurance, and constitutional law. His judgments show that he believes the Supreme Court is a court of equity and justice and does not always go by the mere letter of law. In the case of Vashisht Narayan versus the state of Bihar, Justice Vishwanathan held that the appointment of a police constable could not be rejected merely because there was an inadvertent clerical error by him in entering his date of birth in the application form. He, in fact, held that justice cannot be forsaken on the altar of technicalities, quote unquote. In the case of Ashok Kumar versus New India Insurance, Justice Vishwanathan reversed the judgment of the National Consumer Commission and has allowed the claim of an insured person, holding that to deny insurance claim for the loss of a vehicle where there is no violation of the fundamental insurance policy conditions would be violative of law. The delay in intimating the insurance company about the occurrence of the theft or any other carelessness was held not to be a ground to deny him insurance. He also held that for the fault of an advocate, the complainant cannot be made to suffer, and he restored the complaint which was withdrawn by the advocate without instructions from his client. In the case of Nawaz versus the state of Kerala, where the High Court had modified a death sentence for the murder of 4 persons to imprisonment for 30 years without remission, Justice Vishwanathan held that while there is no straitjacket formula for deciding the period of sentence without remission, there are certain factors which can be considered for and against the convict. Against the convict, it could be the number of victims, their age and gender. And again, for the convict could be his young age and his remorseful conduct. This is the landmark judgment. In the case of Qazi Akhuluddin, another landmark judgment, but this time related to compensation under the Land Acquisition Act of 1894, he sets out 3 primary facts to be considered while granting compensation. This is the characteristic of the land, the future potential of the land, and interestingly, he adds factors denoting market sentiment. This judgment balances the government's power to acquire land with the interest of landowners to get a fair compensation. Sir, can I request you to please address the gathering and formally declare the 5th summer school as closed? Over to you, sir.
Thank you, Shireen, for that very, very generous introduction. Good evening, friends. Mr. Gregory Vijendran, thank you for your insightful address from Singapore. Mr. Hassan Irfan Khan, thank you for participating and giving your views. And I was particularly happy that you pointed out to the live telecast and you're watching them after the court proceedings there. But you will be happy to know that some of us catch up with your live proceedings too, including the recent 13-bench one on the reserved seats matter, or what you call the Maksus Nasiste. And so that was a happy thing to know from you that you too catch up with ours. Mr. Jawad, Ms. Shireen, Mr. Santana Krishnan, and all friends here, I am absolutely delighted to be with you at the closing ceremony of the summer school. At the outset, let me congratulate Nivaran and the co-sponsors, the Commonwealth Lawyers Association, the Singapore International Mediation Center, and the Youth Bar Association of India for putting together this fantastic, program. What is significant is that you've had a galaxy of speakers speak to the participants on a wide range of topics. So I am not going to talk to you on the basics of mediation because you are very well aware of all of that. I am only going to share with you the recent experience that the Supreme Court of India had. In fact, as late as the last week, where we had in the Supreme Court for a whole week the Lok Adalat. And I was in the monitoring committee and I was on the bench on all 5 days, including an opportunity to preside on the last day. And by Lok Adalat, we don't sit on the dais of the judge because we have bar members also joining us. And we settled in 1 week about 1,000 cases. And on the last day, the bench which I presided settled 40 cases within a span of about 5.5 hours. And the reason why I am adverting to that is, if only we had the orthodox technique, which your participants must have learned, maybe our turnover would have been much more. In fact, these were not cases which came to us as settled. Some came to us as settled, but very often it was the claimant in the motor accident claim on one side and the insurance company on the other. And we were in court trying to work out a settlement, with none of the orthodox techniques that you as mediators would have deployed. And it is very significant because Mr. Irfan Khan mentioned about the human rights and rule of law with which Commonwealth Law Association has been associated with. In fact, mediation in the end analysis gives impetus to a rule of law. Why do I say that? I have before me the statistics of pendency in the Indian courts. And I sincerely feel, as a judge in the apex court, that to address this problem of pendency, mediation as a concept, as an idea, as a method, is going to be one of the most essential component in addressing the issue of pendency. Now, you look at these mind-boggling figures. I'm sure other countries, not sure about Singapore because they perhaps have it under control. We have been having Indo-Singapore exchange programs, and we have been benefited by your judgments. But I'm sure the pendency must be of some level. But look at our pendency. We have currently 4.45 cases pending in the 4.5 crore cases pending in the district courts, about 60 lakh cases pending in the high courts, and about 83,191 cases pending in the Supreme Court of India. Now, if the Lok Adalat manned by some of us could settle on a single day about 40 cases, you can imagine what trained mediators could do. So I think the way forward is what you have started, to upskill the participants in the method of mediation, in the various techniques, and I see from a wide range of topics. So the way forward is, one, training and upskilling. I think you have taken a very big lead. It's your 5th summer school, if I heard you right. The other one, of course, is promoting the better infrastructure. As per the National Legal Services Authority report of March 2024, we have 1,144 ADR and mediation centers and 18,162 deployed mediators. But it is organizations like Nivaran and the other organizations of the same ilk, which will go a very long way in addressing the pendency. Because a litigant at the end of the day wants a resolution for his dispute. And what better way than have it mediated? Because as we have always discussed in the mediation conferences, the difference between an adjudication and mediation is vast. Mediation distinguishes itself from other dispute resolution methods such as arbitration and litigation. Unlike arbitration and litigation, where the judge or arbitrator imposes a binding decision, mediation is a party-driven process and empowers them to craft their own solutions. But what I like about mediation is it offers advantages in terms of efficiency and cost effectiveness. In fact, in the Lok Adalat, we were refunding the court fees in the cases which were settled amicably. And cost effectiveness compared to litigation while allowing the more innovative and flexible outcome. But most importantly, mediation is particularly effective in preserving a relationship, making it especially valuable in family, business, and community disputes. Litigation or arbitration often end on an acrimonious note because one party is definitely bound to lose. That's the underlying idea of a mediation. That apart from this upskilling and upgrading the infrastructure, what this summer school would do is also to create an awareness. I'm telling you, Shirin, because I told you once earlier in one of the conferences and other participants, our experience sitting on the bench when we refer a dispute to mediation and when we suggest to the party is, particularly in matrimonial disputes, they somehow feel mediation means, you have to necessarily patch up as a couple. And it takes a few minutes to explain to them that mediation can be in a matrimonial dispute, unification, which happened. We had 5-6 cases where couples went back, happily together. But it can also mean happy parting in the sense that you go your way, there is a settlement of the dispute and, you move on in life. So I think that awareness as to what exactly is mediation, that it is not, conceding to the case of the other party, I think has to get home. Probably it has gotten home in the big commercial arena, but among individual disputes, I'm sure organizations like Nivaran, very meaning of Nivaran is redressal, would address this issue. But here I just want to touch upon as to what should be the qualities of a good mediator. Not that I'm equipped to say on that, but we recently in India, just addressing the international delegates here who may not be aware, we lost one of our able mediators in Mrs. Sadhana Ramachandran. And I recently read a tribute by one of our distinguished senior counsel in the Supreme Court, Mr. Santosh Paul, writing on sadhana. And I want to read this to the participants. Many of you may have read it on the legal portal Live Law. Mr. Paul writes that Sadhana Ramachandran was celebrated for a great craft of resolving complex disputes through her skill as a mediator. She was also appointed as an interlocutor with the Supreme Court to engage with the protesters at the Shaheen Bagh to address the issue of road closures, etc. She would come across as someone who was forthright, outspoken, and full of empathy. She often spent hours encouraging, cajoling, admonishing, foretelling the parties during the mediation and on the phone long after about the pros and cons of the case. She was always there to pacify them and quell their anxieties. What was so inspiring about sadhana was a passion and conviction in bringing the mediation to a successful close. All this, of course, while she was battling a very grave illness, which she bravely fought till the very end. That was on 1st of August. Even in the midst of an intense personal war, she would always have a cheerful expression and friendly demeanor. The source of her energy is still not known to us. After weeks of persuasion and reaching a settlement, when parties would refuse to sign the settlement, her face would be bereft of any anger, and she would still encourage the parties to think over their decision. This is a lesson to always remain calm and patient, in the face of uncertainty and irrationality. I think this nicely sums up what should be the personal qualities of a mediator. But before winding up, I just want to touch upon an aspect which you have already discussed in your summer school, the importance of partnering technology in mediation. Of course, at the same time, being aware of the ills that, the technology can bring about. The pandemic forced the world to shift to a virtual platform for resolution disputes, paving the way for virtual court hearings and encouraging more online dispute resolution platforms to emerge. Online mediations have also acquired recognition under the Mediation Act 2023. We would have discussed it. Some of the provisions are still to be brought into force. Some of the councils and centers have to be set up, but that's for the policymakers to decide. The advance of technology has led to the following developments in the space of online mediation. Electronic document management system allows parties to share and review documents in an easily accessible manner, most of which is something which you know. Artificial intelligence assisted mediation uses machine learning algorithms to analyze data from past mediations and predict likely outcomes based on the party's behavior. I think AI is something which may not substitute mediation, but it can partner like in litigation. And Mr. Vijendran will be happy to know that in the Indo-Singapore exchanges, we have had the benefit of Chief Justice Sundaresh Menon telling us about how they have partnered. You have all partnered Harvey. And, a big project is being laid out to see how best we can harness AI without substituting the existing system, but to make our task easier. I think AI has a lot of potential for mediators also in at least in, sifting documents, arriving at a set of undisputed facts. Maybe it can be put to both parties so that you start with a common denominator in matters where the facts are very heavy. And I understand from the reading that I did for this valedictory that while still emerging, virtual reality and augmented reality technologies have the potential to provide more engaging and dynamic mediation process. Virtual reality can create immersive virtual environments, allowing parties to have simulated face-to-face interactions even when physically separated. Augmented reality overlays virtual elements onto the real world, providing interactive visual aids during mediation sessions. Of course, one has to guard against, the challenges. Data privacy is one such thing. It's crucial to employ secure platforms and encryption measures to protect sensitive data. The local regulations need to be followed strictly. Parties must be informed about the privacy measures in place and be assured that their information will be handled securely. And technological barriers like internet limited connectivity, lack of digital literacy has to be addressed, and miscommunication and lack of non-verbal cues. Online mediation may lack some of the non-verbal cues that are essential for effective communication and understanding. That can only happen, on a person-to-person with the attributes of sadhana, which we saw, which one may like to replicate. So in the end, while declaring the summer school closed, I only hope that this will be a process which you will keep it going. And I wish Nivaran and the Commonwealth Law Association, Singapore International Mediation Center, Youth Bar Association, all the participants, all success. And I'm sure they'll be able to leverage on what they have learned from the wide galaxy of eminent mediators who have taken time. And I, so happy that they've all taken time to share their knowledge in an industry like this, because ultimately this is how a culture for mediation will set in. And it's extremely important for countries like India and Pakistan, Mr. Irfan, where you are already thinking of having ad hoc judges to be added to court. That is one way, but the other way is to have mediation as an important component to address our pendency so that rule of law is guaranteed. Because if cases pend for very long, it can have its own adverse consequences. Thank you very much for inviting me to participate. I think it has been enriching for me and I wish you all success. Thank you very much.
Thank you so much, Justice Vishwanathan. Many thoughts of yours have really got me thinking. It's been very insightful. In fact, there are things which I think, in spite of being mediators for long, we hadn't really thought about. And I also think some of the things which you've touched upon is the training and the upskilling, and to have a mediation framework in general. I think that is something we all need to look at. And in fact, the present Mediation Act, which talks about skilling and training, we hope it will come into force soon and it'll be streamlined in India. Also, as you rightly mentioned, mediation ensures that relationships, whether it is business or personal, would continue, or even if they end, they would end amicably. So that's an interesting thought which we would need to pursue. Though mediation has come a long way, as you mentioned, there is still a long way to go. And as Robert Frost would say, miles to go before we sleep. So with AI coming in and even otherwise. In fact, in this Sunday's interview of Shabana Azmi, I do not know if some of you may not really know her. She's a doyen of Indian cinema, an actress. She has mentioned that art can be used as an effective form of bringing change in the society. I think to advance mediation, we could do the same. We could use various forms of art, such as interactive plays, street plays, nukkad natak, as we call them. We could have poster competitions, poems, poetry, maybe wall art. Talk about mediation whenever we get an opportunity to do so. And we really need to spread the word on mediation. In fact, maybe we should be like the Indian Olympic hockey team. Keep at it and you are sure to get there. Don't give up. I would now like to firstly thank our audience and participants. Your active participation and engagement throughout this webinar has been remarkable. Your thoughtful questions and comments have enriched our discussions and added valuable perspective. We are so glad that you could join us for the summer school. Thank you. I would like to formally thank SIMC and CLA from the bottom of our hearts for actively collaborating with Nivaran on the summer school, and we hope to continue this symbiotic relationship. A big gratitude and a thank you to Mr. Santhan Krishnan, an advocate and mediator and the founder president of Nivaran, the Supreme Court Mediators of India. The untiring force behind this initiative. Thank you for conceptualizing the International Mediation Summer Schools and making it a reality for the 5th time this year. I also want to thank the Vice Presidents, the Secretary, Treasurer, and Trustees of Nivaran for bringing valuable content to our mediation community and for being a pillar of support to ensure the impeccable execution of the webinar. Gratitude to all my colleagues, friends, and each of you who has participated in this session, whether from behind the scenes or in front of it, to make this seminar a success. Last but not the least, I would like to thank Rahul, a budding advocate and a future mediator, who took care of the technical aspects to ensure that we've had a glitch-free proceedings through the last 12 days. With this, we bring the curtains down on the summer school of 2024. Nivaran wishes you all the best and hopes to see you at our next activity or lecture, and of course, the next summer school 2025. I think the young participants may be keen to know about their certificates. They will be in your mailbox soon. Thank you once again to each of you, and especially Justice Vishwanathan and our guests of honor.
Thank you so much.
Thank you very much.
Thank you, Shireen.
Thank you, sir.
Thank you. Bye-bye.
you.
Goodbye.
Thank you, Irfan.
Thank you, Shireen.
Thank you, Gregory.
Bye-bye.
And thank you, Judge. Thank you, sir. Thank you, Vishnu.
Thank
you,
you very
Judge.
much, all of you.
President Santhan, Hassan,
Thank you, sir.
Jitendra.
But